welcome to Law Minstrel, and I am Mwesi Mudukbe Nyi. Today on this episode, we'll be looking again at legal concepts that are relevant to nursing, but we'll be focusing particularly on the concept of rights. What are rights? I think that this is a question that is very important for everyone, not just nurses, to know. Everyone is interested in knowing what are their rights and whether someone is infringing on them or whether someone is not infringing on them, and where someone has infringed on them, what they can do by way of having that infringement remedied. Today we'll be looking at the legal concept of rights as relevant to nursing. Let me just pause here and ask you again, are you a member of our community? Have you subscribed to our channel? Subscribing to our channel enables you to get our videos each time they drop. And every other thing we have that are exclusively for members of the community, you have access to it. So I enjoin you to kindly do me a favor and click on the subscribe button and automatically become a member of our community. I also enjoin you to share our videos to your loved ones, to your platform, your sphere of influence. And if you appreciate our videos, you can give us a feedback by clicking on the like button, as well as giving us a feedback by way of comments in the comment section. Thank you very much. So we are looking at what rights are today, and I'm going to give us a couple of definitions by various scholars as to what rights are. The first of them is Chris Wigwe in his work Jurisprudence and Legal Theory. He defined rights as what is due to a person by just claim, legal guarantee, or moral principle. So what's due to a person by a just claim, by a legal guarantee, or by a moral principle, Chris C. Wigwe calls that a right. Rights have also been defined as concerned with interests, and indeed as protected by rules of rights. So when interests are protected by rules of rights, they are also called rights. And this definition is by J.N. Samba, a professor of jurisprudence, in his work Fundamental Concepts of Jurisprudence. Rights have also been defined by Stanford Encyclopedia of Philosophy as entitlements, not to perform certain actions, or not to be in certain states, or entitlements that others not perform certain actions or not be in certain states. We will look at an analysis of rights. But before then, let me just sum what rights are in a very loose sense so that you can get a grasp of what rights are. So, rights are first of all created by the law. Anything that is not created, any right, so to speak, that is not created by law is not justifiable or justiciable in the law. So rights are first of all created by the law, and they are entitlements that you are entitled to simply because you are a human person. Those can be called fundamental rights. But a right generally, even when it's not a fundamental right, is what you are entitled to. So sometimes in your place of work or at home, there are things that are your entitlements. You see people using in a loose sense. Oh, this is my right. I'm entitled to this. So when something is your due, simpliciter, it can be said to be a right. So we'll now look at a formal analysis of what rights are in order to properly understand the concepts of what a right is. One must first understand clearly how rights are constructed and what these rights do after they have been constructed. To achieve this, an analysis of rights becomes inevitable. So in analyzing rights, they have been said to consist or in two parts. One, a description of the internal structure of rights, that's the form of rights, and a description of what rights do for those who hold them, and that is the function of rights. So in analyzing rights, we are looking at rights as per their form and rights as per their function. So as touching the description of rights, the internal structure of rights, their form, we rely or take a look at the Hofedian system, which is widely accepted because Hofed did go a long way in analyzing what rights are. So we'll be looking at the forms of rights, the Hofedian analytical system. So rights are said to comprise of 4 basic components, and these components under the Hofedian analytical system are called the Hofedian incidents. This name, Hofedian system, is given after Wesley Hofed, who is said to have lived between 1879 to 1918. He was an American legal theorist who discovered these incidents. According to him, rights comprise of 4 incidents. These incidents are the privilege, the claim, the power, and the immunity. Each of these Hofedian incidents has a distinctive logical form, yet they are not mutually opposed one to another. They don't work in exclusion. Rather, the incidents do fit together in a complementary manner, creating a complex molecular right. We will first look at the first incident that Hofed gives in relation to right. You remember we said there are 4 incidents, 4 Hofedian incidents under the concept of rights. So for Hofed, anytime you hear rights, it means that these 4 incidents or these 4 characteristics exist before you can say that these and these are rights. So he says that when you say a right, there is an incidence of privilege, there is an incidence of a claim, there is an incidence of power, and there is an incident of immunity. So we are first looking at the first incident, which is the incident of a privilege, otherwise known as liberties. In other words, a right should give to someone a set of privileges or a set of liberties. So to understand this, we'll look at an example. So you see, you have a right to pick up a shell that you find on a beach. This right is a privilege. So when you say that somebody has a privileged right, or a right is putting forth an incident of privilege, it's like saying A has a privilege to do something if and only if A has no duty not to do that thing. A has a privilege to do B if and only if A has no duty not to do B, then you will say that A has a right. And that right imputes in him a privilege. So in other words, when you say that you have a right to pick up a shell on the beach, you are in effect saying that you have no duty not to pick it up. But if you have a duty to pick it up, it is no longer a privilege. It therefore means that a right does not put a duty per se on you. Once it's a duty, once it goes into the realm of duty, it has veered off the realm of right as well. So as such, you will not be violating, since you don't have a duty to do that thing. You are not violating anything by not doing it. So I have a right to pick this pen up. I should also have a right not to pick it up. But if I don't have any right to refuse picking it up, then if I have a duty on me that I must pick it up, then it is no longer a right I have. I am now duty bound to pick it up. The failure of which makes me liable for refusal to pick it up. So a right normally should impose a duty on another person and not on the beneficiary of the right. In other words, privileged rights stipulate that their bearer has no duty not to do. So, to bring it nearer home, a license to practice nursing imbues on you, the holder of that license, or on you, the licensee, a privilege to engage in licensed activity of nursing practice. Thus, someone with a nursing license has no duty not to operate as one in the licensed ways. If you have this license as a nurse, you can elect to practice nursing and you can elect not to practice nursing. You are not duty bound to practice nursing. You can just get the license and just go and put it in your house, or put it under a bushel, or put it under your pillow and just simply be sleeping on it. You are not duty bound to practice nursing simply because you are a licensed nurse. The second incident of Hofeld system of analysis is the claims, that a right should come with a claim. To understand this, I'll also give an example. A contract between a master who is an employer and a servant employee confers on the servant employee a right to be paid wages. This right that it confers on him to be paid wages is a claim. So A has a claim that B should pay him wages if and only if B has a duty to A to pay the wages. And I hope that that is well understood. So as a licensed nurse, for instance, you are employed, say, by Reverend Father Moses Adasu University Teaching Hospital. As an employee of that teaching hospital, you are entitled to be paid wages. Those wages are your claims to the teaching hospital. So you are entitled to that claim if and only if the university teaching hospital has the duty to pay such wages. So that's what is meant by a claim as an incident of rights. And I truly hope that that's understandable enough. Then we'll now go to powers also as an incident of the Hofeld analysis. Power is one of the two incidents which define what Hart called secondary rules. So secondary rules are rules that specify how agents can introduce and change primary rules. Now, primary rules, on the other hand, are rules requiring that people perform or refrain from performing particular actions. So, from what I have said, it is clear that Hofeldian power is the incident that enables agents to alter primary rules. To further understand this now, I will also give an example. So, for instance, A has a power if and only if A has the ability to alter her own or another's Hofeldian incidents. So, in ordinary sense, power is the capacity to do something. So, power as an incident of rights is that rights should vest a party with the power to do something. And that power to do something can alter the 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 person's personal situation or alter another person's situation. So, for instance, as a nurse, you are perhaps a matron or you are a senior to another nurse. Let me just use the example of a matron. And now you have staff nurses on duty. You come into the ward and you see a nurse sitting down, whereas there is a dressing to be done and the person is on the schedule to do that dressing and the person is sitting down. And you ask the person to stand up and go do the dressing. The person has the duty to respond to you because you have a certain power to alter the person's situation. That is an incident of power. And I truly hope that you get it very clearly in that in the manner that I've put it. So finally, powers can alter first order privileges and claims. Powers can alter people's privileges. Powers can alter people's claims, as well as other incidents. Power can alter such things. So power rights are greatly used in developed legal and political systems to alter the authority of others. Generally, that's what a power is. We will now finally look at immunities. And an immunity is like a shield to power. So power may look like a sword, and immunities are like shields towards such a sword. So this is the fourth and final incident we will examine. To understand how an immunity works, I think the best way also will be to give an example of how immunities work. When A has an immunity, or when A has the ability to alter B's Hofeldian incidents, then A has power. When A lacks the ability to alter B's Hofeldian incidents, then B has what? Immunity. And that's why I said immunities, they act like shields against power. Because power is coming to alter your position, and immunity is there to shield or truncate power's power to alter your position. It's all right, thank you. So B has an immunity if and only if A lacks the ability to alter B's Hofeldian incidents. So for instance, a nurse is engaged in the civil service. Such a nurse has the right not to be dismissed when a new government comes to power. This right is an immunity corresponding to an absence of a power in some other party. The government in power to alter the right holders or the nurse's normative situation in some way. Okay, so you find that in some countries and some governments, when they come into power, they may just want to dismiss people. You have an immunity against that their power to dismiss you, if in law you are protected from such dismissal. That's what is known as an immunity. So we will now be looking at opposite correlatives, and to do this, the best way that we look at it, that you understand eventually, is to share my screen, and I'll be doing that for you to get it very well. The opposites and correlatives, how these incidents of rights that are given by Hofed are arranged as to stand opposites and to stand as correlatives. So Hofed, in order to show the logical structure of his system, arranged the four incidents discussed above in tables, and these tables comprise of opposites as well as correlatives. In an effort to complete the tables, he did something. He introduced new terminology. For instance, if a person A has a claim, then A lacks a no claim. A no claim is the opposite of a claim. I just want to ask you to just calm down and follow properly. For him, if A has a claim, then A lacks a no claim. So you cannot have a claim at the same time have no claim. That's what he means by if A has a claim, then A lacks a no claim. So now, and if a person A has a power, then some person B has a liability, because a power cannot come without someone being liable. So when A has a power, then some other person B is liable for that power that A has. So a liability is now a correlative of a power. So in other words, the opposite relates to the same person, while the correlatives relate to a second party in relation to the first party. I will now share my screen with you for you to look at opposite. So here are the opposites now. If A has a claim, then A lacks a no claim. The second is, if A has a privilege, then A lacks a duty. So because you cannot have a privilege and at the same time be having a duty. Then he also showed that if A has a power, then A lacks a disability, because you cannot be having power and at the same time be disabled. And finally, that if A has an immunity, then A lacks a liability. So he did these opposites to show that when you have this, you cannot have that. So he also did a table on correlatives to show the things that come together. So when one of them occurs, the other must come along. That's why they are correlatives. They are correlated. They are like Siamese twins. They must go together. So the first that he gives is that if A has a claim, then some other person B has a duty. In other words, A cannot have a claim in vacuum. He must have a claim from someone or against someone, and that someone against which he has a claim owes him a duty. So a claim cannot rest without a duty. So a claim and a duty are what? Correlatives. Then the second correlative he gave is that of a privilege and a no claim. You cannot have a privilege and not have a claim. When you have a privilege, it must come with you. If you have a privilege, it means that there is no claim lying against you. So if A has a privilege, then some person B has a no claim. The third correlative is that of power and liability. Power and liability. So if A has a power, then some other person B has a liability towards A who has that power. And finally is the correlative of an immunity and disability. If A has an immunity, then some other person B has a disability like me. So we now go to types of rights. And rights are classified into various types, albeit dialectically. Now, what is meant by this? It means that they are classified in sets of opposite meanings. So, to this end, we are going to be looking at about 9 of such classifications. The first we'll be looking at is perfect and imperfect rights. So from the way they are placed, you will see it sounds as if they are placing it like words and opposites or words and antonyms. Perfect and imperfect rights. The second is negative and positive rights. The third is rights in rem and rights in personam. The fourth is proprietary and personal rights. The fifth is principal and accessory rights. The sixth is primary and sanctioning rights. The seventh is legal and equitable rights. The eighth is vested and contingent rights. And finally, active and, you guessed it right, passive rights. So we'll look at perfect and imperfect right. So a perfect right is what it is. It's actually perfect. A perfect right is said to be one which correlates with a perfect duty. So when A has a right and that right vests upon B a perfect duty, then you say that kind of right is a perfect right. A perfect right is a right that corresponds with or coincides with a perfect duty vested on another person. So a perfect duty, on the other hand, you may wish to know, is one which is not only recognized by the law, but one which the law would also enforce. So if it is a right that, though recognized by the law is not going to enforce it, is not a perfect one. Or if it's the other way around, which is difficult if there is ever one, such a thing that can be enforceable in law and not conversely recognized in law. I've never come across such. So a perfect duty is one which not only is recognized in law, but the law is willing to enforce it and is actually enforceable in law. So a duty will be said to be enforceable when the breach of it grants the one to which it is owed the right of action in a court, either in civil proceedings or in criminal proceedings. That is what is meant by a duty enforceable in law. So conversely, an imperfect right is one which does not correlate with a perfect duty. So, but instead correlates with an imperfect duty. An imperfect duty, on the other hand, is a duty which is not fit for enforcement. For this reason, it usually is left to the discretion of the person. That person in which it is vested is usually rested on his unfettered will to do it or not to do it. So an example of an imperfect duty is a claim that is barred by the lapse of time. And I will give an example for those who do not get it. So if there is a time within which that duty was supposed to have been performed, and then that time has now lapsed. That duty is no longer a perfect duty, so you can't enforce it. But if the person who owed you that duty now decided in his own discretion to do it for you, fine, can go ahead and do it, but the law will not be able to compel him to do it because of the lapse of time, the time which has already lapsed. Again, claims that are unenforceable by reason of the action of some special form are also imperfect duties because they are contingent upon something else. So we'll now look at negative and positive rights. The holder of a negative right is said to be entitled to non-interference, while the holder of a positive right is entitled to a provision of some good or a provision of some service. A right against assault is a classic example of a negative right. Why is it a negative right? It stops a person from doing something. It restrains a person from doing something. So why a right to welfare assistance is a prototypical positive right? Because the duty enables another person to do something to you, whereas a negative right restrains someone from doing something to you. A positive right empowers the person to do something to you. So, to put it in another way, a negative right corresponds to a negative duty, while the positive right corresponds to an equally positive duty. In order for you to understand this better, I think that we should rely on another example. So, A has a negative right to B, where B has a corresponding duty not to harm A. That's a negative right. A has a positive right against B when B has a corresponding duty to pay A something or do a certain thing for A. Then that is a positive right. Okay, we'll now go to rights in rem and rights in personam. A right in rem is known as a real right, while a right in personam is also known as a personal right. So when you just remove the L from personal and put M, you know that that is personam. So a right in personam is a right in person. It's a personal right. Then a right in rem is a real right. So the former corresponds to a duty imposed upon persons in general or even the whole world, whereas a right in rem corresponds to a duty imposed upon distinct persons that you know. So I will give you an example. For instance, a landowner has a right in rem. He has this right against the whole world, against trespass to his land. That's a right in rem. It's a real right, and it's a right against the whole world. But where a house owner, for instance, rents out his house, he has a right in personam towards Lagbaja, who is a tenant in his house, or towards B, who is a tenant in his house, or towards Nwese, who is a tenant in his house. So a right in personam usually lays against a distinct person that you can identify. It's all right. So we'll now go to proprietary and personal rights. So a proprietary right may be loosely described as someone's right in property. So they are property rights. They make up a man's estate, his assets, the sum total of a man's wealth is actually his what? Proprietary rights. On the other hand, the personal rights in this sense are a person's status, his personal condition. So for instance, a person's citizenship status, his family status, his standing before the law, these are all what makes up a person's personal rights. I'll now go to principal and accessory rights. And I think that even from the nomenclature of this is a little clear what principal. So that principal is focal and the accessory are the rights that comes along with that which is focal. So a principal right, as the name implies, is the main right, while the accessory rights are those as the name implies are only appendages and are only additionals or additives that just follow the principal right. So the principal right can stand on its own, whereas the accessory cannot stand on its own, because an accessory must be an accessory of something, isn't it? So the accessory rights cannot stand on their own, while the principal rights can stand on their own. It's all right. So for instance, the ownership of the land is the landlord's principal right, while the rent and the covenants under the lease are only accessory rights to the principal's right of ownership in the said property. We'll now go to 6, which is primary and sanctioning rights. So all rights are generally primary rights, save where that right in question is one that arose from the breach of a primary right. So to understand this better, here is an example. A has a primary right where B has a certain duty to A to do or not to do. Where B now breaches that duty to do or not to do, a right of sanction will now fall to A, which can be in form of damages. This will arise in favor of A against B because B has failed to do or not to do that thing towards A. That's what is meant by primary and sanctioning right. So your primary right is your basic right. If you have a primary right against someone, it means that that someone has a duty against you. If that someone does not breach that duty he has against you, a sanctioning right cannot arise. So a sanctioning right arises only when someone who owes you a duty breaches that duty. When he doesn't breach that duty, then a sanctioning right will not arise at all. So we'll now look at the 7th, which is legal and equitable rights. The distinction between legal rights and equitable rights lies in that the former are rights that are recognized in common law courts, while the others are rights that are recognized actually in equity, also known as the Chancellor's Court or the Court of Chancery. So there are strict rules to follow to obtain a legal right. Where such rules are not completely followed, one may be unable to obtain a legal right but an equitable one instead. So where two conflicting rights or claims of a legal and equitable nature now coincide by A and B respectively, the legal one shall prevail. So the rule is that where equitable rights and legal rights coincide, the legal right shall prevail. Apart from that, where two equal right claims by different persons coincide, then the first in time shall also prevail. We'll now look at 8. The 8th classification is vested and contingent right. A right will be said to have become vested when all that ought to occur before it will accrue to a person have already accrued. So have already occurred. So when everything that should occur for that right to become yours occurs, then that right will become vested in you, and at that time that right will be known as a vested right. When this is the case, the beneficiary of that right is said to be vested with that right. Understandably, the term is therefore descriptive of the nature of that right, as these rights become vested in the beneficiary solely upon the happening of certain facts that ought to happen or ought to have happened. A contingent right, on the other hand, are rights which ought to be vested upon but cannot, because only some of the things which ought to happen for them to become vested have happened. So there are certain set of things which ought to happen for that right to become vested, but not all of them have happened. Then that kind of right will be said to be a contingent right. So their being vested becomes contingent upon the happening of a thing or two or more that ought to have happened but have not happened. But some things which ought to have happened, let's say a set of things ought to have happened before that right will become vested in you. Some of the things have happened, some are remaining. Then that right will be said to be contingent upon the happening of the things which remain to happen and have not yet happened. So lastly, we'll look at active and passive rights. The difference between active and passive rights can be clearly illustrated using the Hoffedian incidents which we just studied. For instance, the privilege and the power incidents are active rights that relate to their holders' actions. On the other hand, the claim and the immunity incidents are passive rights which regulate the actions of others towards you. So one way to identify active rights is that they can be seen in such statements as A has a right to this. On the other hand, passive rights can be seen in such statements as A has a right that B should this. So that's a passive right. Thank you. With this, we've come to the end of this episode on rights, and honestly, I did enjoy going through this episode on rights because rights are so important to everybody. I'll do a quick run through what we did in terms of rights generally, and then we'll wrap up on this episode of rights. So we did a general definition of what rights are or what a right is. Then we looked at the analysis of rights, and in doing that we looked at the form of rights and particularly examined the Hoffedian analytical system of what rights are. And we saw that for Hoffed, rights have four incidents, which are the privilege, the claim, the power, and the immunity. We examined all of that. Then after that, we looked at the classification of rights, and we said that the classification of rights is done dialectically. So it's done in opposites like words and antonyms. And we examined 9 of those classifications. And that is where we are wrapping it up today on what rights are. Thank you so much for sitting with me through the episode. I would like to tell you again to share this episode to others. Please, you have not become a member of my community, please do join by clicking on the subscribe button. It will enable you to get our videos as they drop, and every other engagement we want to be engaging with members of our community, it will only come to you if you are a member of the community. And is there anything you want to discuss with me, you can meet me in the comment section. I'm always there. And finally, punch the like button and let me know that you like and have enjoyed this episode. Till next time, I am sincerely yours, Mwesi Dupe. Thank you.